Good morning, this is your Kelso Report for Wednesday, August 31st. I'm your host, Clark Kelso. Well, an attorney's duty to maintain the confidences of his or her client is one of the most important professional obligations an attorney has. The twin duties of confidentiality and loyalty are, after all, the cornerstones of an attorney's fiduciary obligations. So what happens when a lawyer discloses confidential information acquired in the course of representation to a government regulatory agency? Well, the 2nd District faced this situation in Fremont Reorganized Corp versus Fagan, where a corporation's former general counsel and in-house lawyer, in response to being terminated by the company, disclosed to the insurance commissioner, as liquidator of a related company, that his former clients were planning to auction certain artworks that he claimed were owned by the related company. The insurance commissioner commenced an adversary action against the former client company in the liquidation proceeding. The disgruntled former counsel also filed an action against his former client for wrongful termination and other claims. In that action, the company filed a cross-complaint, alleging, among other things, breach of fiduciary duty and breach of confidence. The former lawyer then responded by filing a motion to dismiss under the anti-SLAPP statute, asserting that the cross-complaint arose out of his protected communications with the insurance commissioner. A cause of action is subject to a special motion to strike under the anti-SLAPP statute if the defendant shows that the cause of action arises from an act in furtherance of the defendant's constitutional right of petition or free speech in connection with a public issue, and the plaintiff then fails to demonstrate a probability of prevailing on the claim. The purpose of the anti-SLAPP statute and motion is to provide an early procedural remedy to dispose of lawsuits brought to chill the valid exercise of a party's constitutional right of petition or free speech. The 2nd District agreed that communications with the insurance commissioner were protected activity under the anti-SLAPP statute, and that the breach of fiduciary and confidence claims arose from that act of communication. However, the court also held that the company had successfully demonstrated a probability of prevailing on its breach of fiduciary duty and breach of confidence claims. The former attorney argued that California's general litigation privilege precludes liability on the breach of confidence claim, essentially contending that his disclosure was in the context of the insurance commissioner's ongoing liquidation proceeding. The court rejected this defense, broadly noting that the litigation privilege, if applicable here, would preclude essentially any action by a former client against an attorney for breach of professional duties arising from communicative conduct in litigation on behalf of the client. And that result would fundamentally undermine the attorney-client relationship. Based on the presumption that the former attorney acquired confidential information in the course of his representation, and the circumstances of the lawyer's employment termination and subsequent call to the insurance commissioner, the court ultimately concluded that it was reasonable to infer the lawyer used or disclosed confidential information in informing the commissioner, and that conduct probably constituted a breach of fiduciary duty and breach of confidence. Accordingly, the court held that it was error for the trial court to have dismissed those claims under the anti-SLAPP statute, and it remanded the case for further proceedings. The lesson for lawyers here should be clear. Courts will not permit the anti-SLAPP statute or the litigation privilege to be used as a shield by attorneys for unprofessional conduct and breaching the duty of confidentiality and loyalty. Our first couple of one-liners are in the area of criminal law. First, the Sex Offender Registration and Notification Act imposes criminal penalties on any person who, quote, knowingly fails to register or update a registration as required by this act, close quote. In United States v. Crowder, the Ninth Circuit held that the government need not prove that the defendant had knowledge of the Act's specific registration requirement. Instead, the court held that it was sufficient that the defendant knew he had failed to register or update his registration, which does require knowledge of a registration requirement, but not the specific registration requirement imposed by the federal act. As the court noted, this is consistent with the long-standing rule that unless the text of a statute dictates a different result, the term knowingly merely requires proof of knowledge of the facts that constitute the offense, in this case, knowledge of the failure to register, not a culpable state of mind or knowledge of the law. Next, in People v. Parodi, the First District held that a conviction under Penal Code Section 4573 for willfully bringing a controlled substance into a jail facility made the defendant ineligible for drug treatment under Proposition 36. Prop 36 was intended to divert defendants convicted of simple possession to drug treatment in lieu of imprisonment, and its provisions apply to defendants convicted only of a, quote, non-violent drug possession offense, close quote. Section 4573, however, is not focused on simple possession. Instead, its focus is upon the act of bringing unauthorized controlled substances into a jail or prison. The First District thus held that the crime of bringing a controlled substance into a correctional facility, even when the drugs are intended entirely for personal use, does not come within the phrase nonviolent drug possession offense, and therefore Proposition 36 does not apply. He doesn't get diversion, he gets jail time. Next, a property law case in Hacienda Ranch Homes v. Superior Court. The Third District held that the evidence established as a matter of law that the plaintiff in a quiet title action had failed to establish a basis for ouster of his co-tenant of unimproved property. The plaintiff had dissed the entire property a couple of times a year, posted a for sale sign near the property, and they'd introduced themselves at a public meeting as owners of the property. But to establish ouster, the plaintiffs needed to engage in open, notorious, and unequivocal conduct adverse to the co-tenant's interests. The plaintiff's conduct was ambiguous, not particularly open and notorious, and did not bring to the attention of the co-tenant the adverse claim of ownership. In these circumstances, the plaintiff did not secure the property through adverse possession under a claim of right. Now, an interesting taxes problem in Charter Communications Properties versus County of San Luis Obispo. The Second District held that in determining the fair market value of a television cable franchise, the county assessor could use the reasonably anticipated term of possession, even though that term was longer than the stated term of possession in the current franchise agreement. On the facts of the case, the assessor found clear and convincing evidence of a mutual understanding between the county and the owner of the franchises that the anticipated term of possession was going to be longer than the stated term. The assessor concluded that the reasonably anticipated term was 15 years, substantially longer than the between 4 and 10 years remaining on the existing franchises. A criminal sentencing case in People v. Torres, where the defendant was convicted by a jury of attempting to dissuade a victim or witness from reporting to law enforcement certain alleged crimes. However, a judge who did not preside at the trial imposed a sentence for the greater offense of dissuading a victim or witness by force or a threat of force or violence. The defendant was also subjected to a 3-year enhancement and a conduct credit limitation when there was no evidence that the witness dissuasion qualified as a violent felony. The court remanded this mess for resentencing. You can't sentence someone for a more serious crime than they have been convicted of. In the public employment area, in Brown v. Cheung, the Third District held that Governor Schwarzenegger's furlough order, which the Supreme Court held in Professional Engineers in California Government v. Schwarzenegger, was ratified by the legislature and therefore legal, extended to the state's other constitutional officers, including the Lieutenant Governor, Secretary of State, Treasurer, Attorney General, Superintendent of Public Instruction, and members of the State Board of Equalization. In reaching this conclusion, the Third District rejected a variety of arguments grounded in the division of executive authority in California's executive branch and separation of powers. At the end of the day, the legislative ratification carries the day on what is at base a budget action. Finally, in the area of torts in Jones versus ConocoPhillips, the Second District held that a complaint for wrongful death from exposure to toxic chemicals in products with which the decedent worked during his employment at the Goodyear Tire and Rubber Company sufficiently alleged causation to survive a demurrer. The plaintiff sued 19 manufacturers of 34 different chemical products, alleging each product identified in the complaint contained toxins that were a substantial factor in causing the decedent's illness and death. The trial court had accepted the defendant's argument, based on the Supreme Court's decision in Bockrath v. Aldrich Chemical, that the complaint needed to identify the specific toxin contained in each hazardous product which caused harm. The Second District disagreed, holding that the trial court had incorrectly interpreted Bockrath. Bockrath required identification of each product which allegedly caused harm because of the presence of toxins in that product. Absent that identification, the complaint would have been speculative. But Bockrath did not require specific identification of the precise toxin in the product. It is sufficient to plead that the identified product contained toxins which caused the decedent's illness and death. Further specification of the facts, the identity of the toxins, can wait for discovery and a possible motion for summary judgment. And that's it for today's Kelso Report. Have a great day in the law.